Mr. Horton, it's your turn.
Thank you, Mr. Chairman. I'd like to, I also, like Mr. Foster, am going to proceed a little bit extemporaneously here based on a series of sticky notes that I put together when he was making his presentation. So I actually did put together a bit of a slide presentation, though, but that's not going to take me through the whole 30 minutes. Let's go to the first slide. And going back to basics, okay? When you heard Mr. Foster's presentation, it sure seemed to me as though he was asking the tribunal to shift the burden to Guatemala on a number of issues. So, going back to basics, claimant filed this case. They have the burden of proof and the burden of persuasion. Guatemala does not. So we ask the tribunal to please keep this in mind as you consider the evidence and deliberate and render your award. We think this is very, very important. I don't think it's a mistake that the burden of proof is being, there's an attempt to have it shifted over to Guatemala because, as I mentioned, there is a serious problem with the proof that's been presented here by the other side. Quality of the evidence, I mentioned it in the original presentation. I think it's worth underscoring yet again. The presentation that's been made, both here and throughout the hearing and in the papers, I think will back up what we are saying in terms of the evidence that has been presented by claimant for its case. The newspaper articles, the inferential leaps, the speculation, that does not make out a CAFTA claim. We ask that the tribunal focus on the contemporaneous evidence, the documents, the emails, the contracts, the Lesivo opinions, the declarations by witnesses. We ask that you focus on those things especially as corroborated by the contemporaneous writings. And we believe that when you do that, you will reach the same conclusion we have, which is the claimants have not established any of the elements of their CAFTA claim. Now, there's been discussion about presidential liability, and because we do think it does bear on the issue of the reasonableness of the action taken by President Berger at the time that he issued the Lesivo Declaration, we wanted to highlight again for you the appropriate articles. Articles 153 to 155 of the Guatemalan Constitution. We believe that they establish that any public official, including the President, and you heard Mr. Mayota tell you yesterday, claimant's expert, that those clauses do apply to presidential action, as Mr. Aguilar also confirmed for you. The question is whether when confronted with a situation where your advisors are telling you you have a contract that is illegal, is the President compelled to take action there? And if he doesn't, does he face the risk of personal liability? We believe these articles confirm that that the President does incur that risk and would be liable or would face the risk of liability for failing to take action. There was a question asked, it's been asked several times, are there any cases where a President has been confronted with a request for a Lesivo Declaration where that resulted in personal liability to the President? And both experts told you that they weren't aware of any such case, and we're not aware of one either. But it's probably not surprising because there probably aren't too many presidents who disregard the advice of their legal advisors when confronted with an illegality. Probably they follow that advice, as President Berger did here. Whether he had discretion to take the action or not, we understand this tribunal has ruled already in the context of jurisdictional hearings that you believe the President has discretion to take action. Well, whether the President had discretion to take action or not is really doesn't address the question of whether the President would be liable for failing to respond to an illegality. He may or may not have had the discretion. Even if you assume that he did, the exercise of that discretion to not respond to an illegal situation can place the President at risk of personal liability under Article 153 through 155. You read those articles, nowhere do they say there's an exception for public officials when they have discretion to decide, to make decisions. Nowhere do they say that. We thought it instructive to point to you testimony from Mr. Mayotta on the issue of what a public official should do when confronted with an illegal contract. Again, while Mr. Mayotta claims that a president has no liability for failing to declare an illegal contract lesivo, as I understand his opinion, because he has discretion to make that decision, his prior testimony does suggest that public officials must, and I underscore that word, must take action when confronted with an illegal contract in order to elevate that illegal document to the competent authority for it to be dealt with. And I cite to you here transcript from the jurisdictional hearing where Mr. Mayotta, in his own words, tells you that very thing. And that is what President Berger did here. He acted in the face of advice that the FEGWA overseer had executed a contract that was illegal. He elevated the issue to the appropriate competent authority, and that was the Attorney General of Guatemala, who then took it to the judicial branch for the judicial branch to make the decision about whether the contract is or is not lesivo. I'm going to leave the screen up, which talks about damages. I'm going to get to a few other issues before I get to damages. First of all, on the issue of planning for this case, I think we highlighted a number of things on claimant's immediate planning for bringing this action once the lesivo declaration was issued. Mr. Foster said that the record is going to substantiate that Mr. McSwain said he was hired in 2006 or 2007. I submit to you that it's clear in the record that he admitted he was hired in 2006. He was then asked when in 2006, and he says he wasn't sure, but he said it was in 2006. And again, the fact that they are hiring their damages expert, their real estate damages expert, it has to have been a short months, even if you give them the benefit of the doubt, after the lesivo declaration. That was issued basically end of August. So just very short months after that, giving them every benefit of the doubt, that tells you that they were planning to bring this case then, as opposed to responding to the situation, as opposed to trying to salvage their investment if they really thought it was at risk, as opposed to going out and trying to obtain from customers and reassure them that the business was going to go forward. On the issue of the investment that was made and the phases, we've heard time and time again that claimant only made a promise to invest $10 million, and they tell us that they only ever were obligated to complete phase one. We don't believe that's what was promised. And that's in part why we said in our opening slides that Guatemala feels misled. You heard the testimony from the FEGWA overseer who negotiated the agreement, and he told you that is certainly not what he negotiated and certainly not what he believed he was getting. And on that point, I think it bears, again, raising the rhetorical question, which I think is really an interesting one. Is claimant really asserting in this case that they only had to build out 200 miles of an 800-mile or a 500-mile, a 500-mile restoration project? They were given over 500 miles worth of land to restore in the railway. Is it really their contention that they only have to build out 200 of those miles and they get to keep the rest of the government land for 50 years to exploit however they like? Is that really what they believe they got from the government? On the issue of industrial squatters, in addition to the points that we made earlier, and I think that it's perhaps worth mentioning one of the ones that I think is perhaps most resonating, which is that they cannot prove that the industrial squatters were there because of the Lesivo Declaration. All of the industrial squatters that they claim are there post-Lesivo, and again, we believe there's a deficiency of proof in whether they were there pre or post-Lesivo. We don't think they've actually submitted evidence to prove that to you, that they were there post-Lesivo. But even if you believe that, what is to say that those industrial squatters didn't go there when claimant announced that they were leaving the country publicly, or as a result of that, or because of that? That happened in 2007, mid-2007, and then very publicly in September 2007. And all of the pictures that you've been provided post-date that event by at least 2 years. On the issue of government, whether any of those industrial squatters are government squatters, even if you get past the other hurdles that we've mentioned, claimants have ignored that in Contract 402, under Clause 11, under Clause 11I, they agreed to provide access to the right-of-way in the event of public need. Okay? Clause 11, which is titled Obligations of the Usufructuary, Clause I says, provide access, one of the obligations. Among other obligations, the usufructuary shall be bound to do the following: provide access to right-of-way in the event of public need, including the access to vehicles, passage, or pipe installation for carrying drinking water or other liquids, for agricultural, irrigation, drainage, installation, and conduction of power or telephone cables. Right? They're complaining about public telephone or power cables being put on their property, but they had an obligation to provide that pursuant to Contract 402, Section I. I'm sorry, Clause 11, Section I. On the issue of the presidential quote, they cited to you C-131. They said that was a government newspaper. Well, you know, reporters make mistakes whether they work for a government newspaper or not. And I just want to correct something for the record. When it was read into the record by Mr. Foster, he said, and I quote, and then he went ahead to read the president's, what he said was the president's words. But if you look at C-131, when they report what the president purportedly said, there are no quotes, I repeat, no quotes around those words. So it's incorrect to say that there was a direct quote of the president in that exhibit. And just to remind the tribunal, that goes to the issue of whether there was any supposed $50 million demand made by the president for restoration of the railway. On the issue of whether they made a sufficient investment, again, they promised $10 million. It's, I think, established in the record that the amount that they invested, whatever it actually is, was not enough to make this into a profitable investment. It just simply was not. And it wasn't enough to do the job that they promised, and at least according to the government's version and understanding of what they promised. And we know that because they themselves admit that it was going to cost at least $100 million, at least, to build out the second of 5 phases that they agreed to restore. At least $100 million. And by the way, when they tell you that they had completed phase 2 and they rely on that letter, well, you heard the testimony from Dr. Gramajo, but ask yourself, why are they going to President Berger in March of 2006 to seek funding for the restoration of phase 2 if they really believed that they had completed their obligations under that phase? Does that make any sense? We were told that there was not one shred of evidence that the claimants were told, that FEG was told that Contract 143 and 158 had legal defects. Well, I think the record establishes that they were told that immediately upon Dr. Gramajo being informed of that. Well, we would cite to you again R8 and R49. Those are that's Dr. Gramajo's letter to Mr. Sen in April 2004, and R9, which is a letter by Mr. Sen to Vice Minister Diaz, which confirms that they knew that the government had problems with the contract, and they were sitting down and negotiating with the government about those problems. On the issue of C-44, I'd like to put that document up if we could. And again, for the record, C-44 is the settlement proposal that was given to Mr. Sen during the meeting that took place on 24 August 2006. First, for Mr. Foster to say that Mr. Sen did not know that he was showing up there to discuss a settlement is contrary to both the testimony of Mr. Sen and the testimony of all the other witnesses who attended that meeting, including Mr. Fuentes, who told you that he had been commissioned by the President to try and find a solution to this, and that he was at that meeting and understood that it was supposed to be a settlement meeting. So the statement by Mr. Foster is contradicted by the evidence of record. The fact that in the precursor of the document, it says that Deed 143 and 158 were submitted to a public bidding process simply reflects that this is a draft agreement. People make mistakes when they draft. For him to suggest here without any shred of evidence that that means that the government was simply going to bypass the very important requirement of a public bidding process is simply nonsense. We know it's a draft. All you need to do is look at the document. There are a number of blanks on it. You can see it on the screen. If we go to the portion of the document that talks about, please, Kelby, I think it's section 3 or 4. Bear with me. Go down a little bit more, please. All right. You can, for 1 second, just highlight fourth for a second. Again, we've made this point during the and just that paragraph. The document on its face shows it's a draft. It talks about the issues to be negotiated between the parties. Of course it's going to contain mistakes. Go down and a little bit more and go to clause 6, please. Okay, and let's highlight that again. You heard from Mr. Foster that during that meeting, no one told Mr. Sen or the other representatives there on behalf of FVG that what the illegalities were, what the issues were that were motivating the Lesivo Declaration. Well, let's highlight all of Clause 6, please. You can see on the face of the document, it says issues to be settled in connection with the onerous usufruct contract, and then it talks about the parties negotiating and deciding upon a number of things. And A says, modification to the onerous usufruct contract involving railway equipment in order to rectify the terms which are deemed to cause lesions to the interests of the state of Guatemala according to the opinions rendered by, and then it sets forth 3 opinions there. Now, if Mr. Sen had, rather than simply rejecting outright the possibility of entering into a negotiation on this, if he, rather than doing that, which is what the record evidence shows that he did, if he would have engaged in a dialogue about this, I'm sure they would have discussed the issues that were set forth in the opinions. Otherwise, there's no way they could have reached an agreement as to those points. They had to, by their very nature, discuss them. But the evidence is that he simply rejected the notion of entering into negotiations. On the issue of whether a public bid was required for entry into force of Contract 143, they made mention, Mr. Foster made mention of the fact that I accurately represented the record on the issue of when Dr. Gramajo was first informed or notified that a public bid was required for Contract 143. And he says that, I'm not entirely sure what the point is that he's establishing, other than some lawyers made mistakes. Lawyers do make mistakes. We all know that. That some lawyers who first looked at Contract 143 and 158 assessed that it had some illegalities and didn't pick up on others doesn't prove anything. Once the government became aware that this was an issue, in other words, once under the Bourget administration and FEGWA overseer became aware that this was an issue, it was an issue that was brought to the attention of the parties, and it was an issue that they focused on. They didn't disregard it. Again, on the issue of causation and damages, I ask you to focus on the issue of their abandoning publicly their position in Guatemala and what that did in relation to any potential damages. And I ask again, why aren't they out there today trying to collect rent? On the issue of the testimony from Mr. Franco about what some official in the court told him about whether or not the lesivo, the opinion from the administrative court on the lesividad would be issued, again, I think it's inherently unreliable. We don't know what the public official, what instruction the public official was given, if any, by whom. We know that Mr. Franco is a lawyer who has been working for the claimant for quite a long time, and we know that his boss is sitting across from us at the table and is one of the lawyers in this case. So we ask you to take all of that into consideration when you assess that statement from Mr. Franco. On the issue of, and this was raised in one of the questions, I believe, by Secretary Eisenstadt, the other countries that have lesivo laws. Well, we've cited to you in the first report of Professor Aguilar, I believe it's section 1, paragraph 1, that there are a number of countries who have lesivo laws. It's not just Guatemala. We've Spain, France, Mexico, Costa Rica, Ecuador, Argentina. And in relation to Spain's lesivo law, you heard from Mr. Foster that that law mentions or provides for an opportunity for the person who's affected by the lesivo declaration to be heard before the lesivo declaration is issued. Well, as made clear in paragraph 48 of Mr. Aguilar's opinion, first opinion, the reason that is provided for in Spain's law is that, unlike Guatemalan lesivo law, the executive has the ability to declare null and void a contract on its own without submitting it to the judicial branch. And under that circumstance, it makes a lot of sense as to why there is an opportunity to be heard given to the person who might be affected. Here, on the other hand, the issue is submitted to an independent judiciary, as you've now heard several times, and the judicial branch, through the administrative court, makes the determination about whether the contract is or isn't lesivo. And the claimant, as you know, or the affected party, is provided an opportunity to be heard there. On the issue of the profitability or lack of profitability of claimants' investment through FEG, again, we've heard that in 2004, there is a calculation that shows, according to Mr. Foster, that there was profit in that year. First of all, I want to point out to the tribunal that he's referring to an exhibit that was provided by Mr. Posner, and that exhibit says nothing about profit. If we could put up the exhibit, it says nothing about profit. What it shows is the EBITDA of the company throughout a number of years when you factor in the trust payments that they claim should have been provided. And you see that in the very last line, add estimated FEGWA trust payments. And what's important to point out is that says nothing about profit. That says what the earnings would be before you talk about income, depreciation, taxes, and when you factor all those out is only when you can determine whether or not there's profit. So that number tells you nothing about whether the company was profitable in 2004. And you see that even adding in the FEGWA trust payments, 1 year later you have a negative number somewhere in the range of over $400,000. We can now put up the slides, please, that we prepared, or go back to the slides that we prepared. There was mention made of the bond of a particular example that was put up, or that was put up by Professor Spiller, and suggesting that somehow Professor Spiller incorrectly is estimating the effect of amortization. The problem with the example that was put up is that it was conducted over a 5-year period and not a 42-year period, which is the correct period to be estimated here, given the length of the usufruct. And when you apply the correct discount rate, you can see, based on this slide, that there is still double counting to the tune of 82%. On the issue of pre-award interest, we believe it should not be compounded. On the issue of the forced loan theory, we don't think that is the proper standard that should be utilized by this tribunal. The proper standard should be the reinvestment rate if any damages are granted and pre-award interest is awarded. And we believe that the correct rate is the one that we have suggested to you, which is the commercially reasonable rate, such as LIBOR plus 2%. And we cite to you here some awards that have used that rate. This point I've already made, which is the lack of profitability. I'd also like to point out that while they talk about a $10 million investment and they talk about the fact that their real estate revenues were soon to be going very, very upwardly in the positive trajectory, that they promised in their bid that they would be using the real estate revenues in order to service $5 million of the what they say is promised $10 million investment. They said $5 million in equity and $5 million in debt, and they were supposed to recover that $5 million in debt through earnings from the easement revenues, but they were never able to do so, and that speaks volumes about the lack of demand based on the projections that they had for the real estate easement revenues. There were questions raised about the possibility of awarding damages based on sunk costs or historical costs. We've included here some slides in relation to this issue. It is our contention that standard would not be appropriate here. That standard, to the extent it's been used, and it has been used by some tribunals, as pointed out by Professor Crawford, is more appropriate or apt for an investment that is cut off at the knees at its infancy. That is not this case. This investment was ongoing for more than 8 years, and we won't belabor the point. We've included a number of slides here, but the point is we do not believe that that is the appropriate standard, and based on the appropriate standard, as we've told you, we believe the fair market value of the investment at the time of the alleged expropriatory act or wrongful conduct by Guatemala, again, the alleged wrongful conduct, is 0. And with that, I thank you again for your time.
Thank you.